Hello, my name's Sarah Lucy Cooper, and with me is Tara McCarthy, and we're both from Thomas More Chambers. Today, we're going to be talking to you about keeping it in the family when criminal and family law come into conflict. I'm a specialist family practitioner, and Tara is a specialist criminal practitioner of many years standing. So, thank you, Tara, for agreeing to participate in this.
My pleasure.
Right. Now, the first issue is obviously for us as family lawyers to think about when criminal proceedings might be relevant in a family court. Now, some of the topics that we can think about are obviously domestic abuse cases, in particular in relation to Children Act applications, but also something in the way of stalking, harassment, possibly coercive and controlling behaviour. Then we move on to some rather more difficult issues, such as care proceedings. They can also be very much engaged with criminal law. And what is, I would say, a newcomer on the block, which is possibly the resurgence of conduct being argued in relation to financial remedy proceedings. And that conduct frequently encompasses criminal behaviour. So perhaps you could tell us then what might constitute domestic abuse.
So, domestic abuse would be within the context of a relationship, physical assaults, people arguing to the extent where they're threatening to kill each other, or behaviour which amounts to harassment, so continued conduct which is unwanted, coercive control, which can include financial abuse. That tends to be within the relationship. Behaviour which is controlling from one partner against another, demeaning, belittling, can involve low-level violence. Sexual abuse, again, is quite a common one, ranging from sort of fairly low-level grabbing, which is unwanted, to rape, vaginal, anal, whatever it happens to be. And obviously, potentially something to be aware of, female genital mutilation, which I think is becoming more of a problem as people become more aware of it.
Right. And how frequently are cases, say, of controlling behaviour, coercive and controlling behaviour, actually prosecuted? Because it's certainly something that we hear a lot about in the family courts.
I think it's prosecuted a lot. It's very common within the scope of a trial alleging rape, for there also to be an allegation of coercive or controlling behaviour, especially if the behaviour involves what are low-level assaults, so common assaults, spanning a period of time. There's a limitation about when you can prosecute a common assault. And so if you're outside that limitation period, you can add to a coercive or controlling allegation assaults, i.e., every time I want to do something, he stops me and he hits me, might result in a bruise. Obviously, if you're talking about a greater level of injury, then you can charge that. There is no limitation. But if it's a bruise or scratching, then you're stuck. And so you would look at coercive or controlling behaviour is commonly on the indictment, I find.
So, for the sake of non-criminal specialists, can you just give us a broad outline of the ladder of the level of assaults with something in the way of an overview vis-a-vis sentencing?
Of course. So starting at the very bottom would be a common assault, which can include physical touching or the threat of physical touching, battery. The threat is the assault. And that has a maximum penalty of 6 months imprisonment or a level 5 fine, which is related to the income that someone has. And the details of that can be found on the Sentencing Council's website. If the injury is significant and causes damage to the skin, then you're looking at the next level up, which is assault occasioning actual bodily harm, or ABH. That doesn't have a limitation. It can include severe bruising. It can involve sort of like scratches or grazes. Maximum penalty, 5 years imprisonment. Again, there's a fine with that. It tends to be custody or community penalties in the Crown Court. Inflicting grievous bodily harm, that's where you've got a much greater injury, but there's no intent, so it's the same penalty, maximum 5 years imprisonment with a fine. Those are similar in terms of how they are sort of prosecuted and how they are dealt with in terms of a penalty. If you intend to cause someone really serious harm, doesn't matter if you did, but if you intend to, then that is the next level up, wounding with intent. Maximum is life imprisonment. And then you have others such as false imprisonment or kidnap, again, life imprisonment. And then you're getting to the most serious, which is murder or attempted murder. And again, life imprisonment.
Right. Okay. Now, quite often in a domestic context, what we see is possibly lower level criminality, but a huge persistence in that criminality, people going on and on and on. I recall when I was a junior barrister representing someone who had just been pursued by somebody for sort of 10 years post breakup. How does that work in terms of the criminal law?
So that would be harassment, and you have to have a course of conduct, so 3 or more occasions. And it depends. We now understand harassment a bit more in the criminal courts, and so we've split it into different levels of offences. So you have your, what I'm going to call entry-level harassment, which is relatively straightforward. That's got a maximum of 6 months imprisonment or a level 5 fine, dealt with in the magistrates' court. Equally, stalking, which is a similar type of behaviour, this sort of persistent, unwanted turning up and things like that, or contact. Again, if there is no fear of violence or threat of violence or serious harm, again, that's in the magistrates' court. So summary only, 6 months maximum imprisonment or a level 5 fine. However, when it starts to get nasty and there's a fear of violence, it can be charged under a slightly different section of the same act. It's therefore possible to try that in the Crown Court. If it goes to the Crown Court, maximum penalty 10 years imprisonment. And that's for where you get the really persistent, nasty threats. And then there's the same equivalent for the stalking element of the offence. So if you have someone that's making really horrible threats continuously, not learning, but getting worse and worse in terms of the fear it's causing, then you've got those 2 options which can be prosecuted, maximum 10 years imprisonment or a fine.
Thank you. I think one of the points to draw out from this